In property law, an easement can be created expressly through a grant, impliedly based on existing or prior use, or prescriptively through adverse use for a specific period of time. But can an implied easement be created if the parties didn't intend to create an easement for the permanent right of use over land? The United States Court of Appeals for the Third Circuit considered this question in Lewis W. Epstein Family Partnership versus Kmart Corporation. Lewis and Morris Epstein owned land in Whitehall Township, Pennsylvania. In the 1960s, the Epsteins leased a portion of the land to the Levitz Furniture Company, and the company built a store. The leased premises were landlocked, roughly 500 feet from the only access road. The store was only accessible through a right-of-way over the land, and Levitz erected a sign on the Epsteins' property directing traffic to its store. In 1975, the Epsteins subdivided the land. Lewis acquired ownership of the portion of the land that Levitz leased and the land northwest of it, and Morris acquired the rest. Lewis and Morris then executed an express easement, creating a non-exclusive right-of-way over Morris's land to provide for ingress and egress to the nearby road. The declaration of easements stated that nothing could be erected over the right-of-way that would obstruct its use. However, the declaration didn't mention Levitz's sign. In 1992, Kmart acquired Morris's land and planned to build a shopping center. Kmart then proposed making substantial modifications to the right-of-way, including removing Levitz's sign to construct a deceleration lane. Subsequently, Lewis, through the Lewis W. Epstein Family Partnership, sued Kmart in the Court of Common Pleas to prohibit Kmart from making modifications to the right-of-way. Kmart removed the case to federal district court, and Levitz intervened. The partnership and Levitz moved for a preliminary injunction, which the court granted. Specifically, the court enjoined Kmart from making alterations to the right-of-way and from removing Levitz's sign, concluding that Levitz had an implied easement over the land. Kmart appealed to the Third Circuit Court of Appeals. After concluding that the district court's injunction over Kmart's plan to modify the right-of-way was overly broad, the court turned its attention to Levitz's sign.